the Income Tax Act that every political party should maintain accounts of where they have received the donations from, who has given them the donations. Now, by the amendment, it says, proviso says, provided that B, in respect of each such voluntary contribution, other than contribution by way of electoral bond in excess of 10,000, such party keeps and maintains record of such contribution and the name, address, and address of the person who has made such contribution. So again, the Income Tax Act that every political party should maintain accounts of where they have received the donations from, who has given them the donations. Now, by the amendment, it says, proviso says, provided that B, in respect of each such voluntary contribution, other than contribution by way of electoral bond in excess of 10,000, such party keeps and maintains record of such contribution and the name, address, and address of the person who has made such contribution. So again, the requirement of keeping a record is omitted for electoral bonds. And then, my lord, D, no donation exceeding 2,000 rupees is received by such political party otherwise than by account pay check drawn on a bank or an account pay draft or use of electronic clearing system through a bank account or through electoral bond. So everywhere, my lord, electoral bonds have been not only introduced, they have been exempt from disclosure under the Companies Act, under the Income Tax Act, under the Representation of Peoples Act, etc. And then, my lord, at page 10, this is of course the Reserve Bank. Reserve Bank Act only says that this will be a new financial instrument which has been introduced. Issue of demand bills and notes, and here it says the amendment at 3 says, notwithstanding anything contained in the section, the central bank may authorize any scheduled bank to issue electoral bonds. At the bottom of page 10 towards. And then, as I said, my lord, in the FCRA, which has also been challenged in this petition, now prior to the amendment of 2016, this is important for the reason that when I make my argument as to what this slew of amendments has done, it has, on the one hand, my lord, introduced an opaque instrument by which nobody can come to know other than the government. It is only the government who may be able to come to know as to who has contributed to whom, because under the scheme, State Bank has to issue the electoral bond. So State Bank has a record of who has purchased which electoral bond. Now, of course, the bonds are bearer bonds. They are freely transferable. So suppose I purchase the bond, State Bank will know that yes, I have purchased this bond. But I can hand it over to somebody else, and that somebody else can give it to a political party. The political party also may not come to know who has donated. Political party, it's open for a political party to say that, well, we opened our office in the morning and we saw these 100 crores of electoral bonds lying under our door. We deposited these electoral bonds. We don't know who has given them, but these are bearer bonds. So therefore, all that the political party will disclose in their accounts would be that out of the total contributions that they have received, donations that they have received 500 crores by way of electoral bonds. That they have received total 700 crores, out of which 500 crores are from electoral bonds. That's all. But that match of who purchased this electoral bond and which party encashed this particular electoral bond, that match, if at all, it can only be done by the State Bank, which is a Government of India institution. Of course, State Bank is also effectively prohibited from disclosing it. But the scheme says that if a law enforcement agency needs to know this, get this information, it may ask the state bank to disclose this. So if at all, only a law enforcement agency, which are all essentially controlled by the government, or the government itself, because it controls the state bank, can come to know only this much, that this particular bond was purchased by this company and this was encashed by this party. But nobody else can come to know this information under the scheme of electoral bonds. Nobody else. They are not even the election commission, because the only account that is submitted to the election commission by the political parties is that we receive so much by way of electoral bonds. They are not obliged to disclose who gave them. In fact, they may even say, we don't know who gave it. We opened our office, it was lying under the door, we encashed it. So therefore, they may even turn around and say that. In fact, there is an interim order of this court in this very case, by which this court said that all political parties should disclose the donors of these electoral bonds to the election commission pending the hearing of this case. There is an interim order to that effect. But when that information is finally seen, I dare say, my lord, that some of these political parties would have said, we don't know. We don't know.
Still on the SBI issuing bonds to persons who are not residents in India?
Yes, the requirement is that they have to give a KYC, whoever purchases electoral bonds. So the identity of the person who purchases the electoral bonds will be known to the State Bank of India. But because they have now opened the route by making this amendment that the limit of 7.5% of the annual profits has been totally removed. So even if you are a loss-making company, or even if you are a company which does no business, just a pure shell company, let's say, my lord, your lordship is aware that in that Adani SEBI matter, they are saying, SEBI is saying, we don't know whether these companies who have invested in the Adani companies from Mauritius and from these tax havens, whether they are in fact owned by Adani or not, or whether they are related to Adani or not. Now it is open to any of these companies to set up a subsidiary in India and donate to any political party of their choice any amount, even if it's a pure shell company, which means no business, no profits, just an amount is received from its parent company, which is registered in a tax haven, and that amount is given to a political party. So one of my arguments